Love it. I love that song. That is, you heard it here, and you will only hear it here. That is Johnny's Got a Girlfriend. It is a custom track made especially for Health Solutions with Shawn and Janet Needham, where Team Needham discusses everything healthcare. Welcome to our midweek podcast. Today we have Bryce McPartland, attorney at law, on our podcast to talk about hospital billing. Great timing considering what's going on with my son's hospital bill. I love it. I appreciate him being here. One thing I do want to get out of the way first is I want to tell you, obviously we've all been dealing with COVID-19, and I am just going to rant a little bit, as you probably have heard me do before. But on this subject, I haven't ranted a lot about it, and I've stayed a little bit away from it from social media, but I've been traveling a lot with work because of COVID-19, and it's been a wonderful opportunity because there's been some areas that we've been able to reach out into that we probably wouldn't have before because Washington was shut down. Today, we are streaming from beautiful Bellingham, Washington, and we've been spending a lot of time in Idaho building that market, and I'm super, super excited for it. So here is one of the things that I wanted to rant about. So as you know, in Washington State, we have a mandatory mask wearing policy Friday. And I don't really know the details of it. Honestly, I don't really care. I don't believe, and I'm just going to say it, I don't believe that wearing masks makes us any safer. I don't believe that that social distancing makes us any safer. That is my opinion. And I also believe that anyone that says that I am self-centered or anybody is self-centered for not wanting to wear a mask, I believe, what if we turn that around and say, I believe it's self-centered for you to tell people to wear a mask and social distance or stay at home. That to me sounds self-centered, okay? Here is what I'm gonna call Shawn's COVID challenge, okay? I got in a debate with somebody on Facebook yesterday that said that the hospitals are going to be overwhelmed if we open up and, don't wear a mask and don't social distance. I'm not buying it. I'm not buying it at all. So here is Shawn's COVID challenge. If anybody notices a hospital that is overwhelmed because of COVID patients, not because of staffing, and their primary diagnosis is COVID, not some underlying comorbidity, and a hospital is full because of it, I will personally donate $100 to a charity of your choice. Call in. You can debate me, 509-537-0411, or you can message me on my own personal Facebook, streaming live at my personal Facebook page and the Moses Lake Professional Pharmacy's YouTube page as always. So get a hold of me. We can discuss details because I really have that much confidence that COVID is not going to overwhelm us. So that's Shawn's COVID challenge. All right, now let's get back to our show today. Bryce, thank you so much for being with us today. We have a lot to talk about. You've got some great ways to deal with, educate consumers about dealing with hospitals being transparent in pricing and overbilling. So, Bryce, tell us a little bit about your history first.
Sure. Thanks, Shawn. Thanks for having me on the podcast today. We'll see if we can't get some information out to folks. So I got a law firm that I started about 8 years ago, primarily based here out of Moses Lake. We've also got a Kennewick office down in the Tri-Cities. I went to law school, graduated from law school in 2005 from Gonzaga, and then worked for a number of injury firms in Spokane, Tri-Cities, in Moses Lake before starting my own operation. I'm admitted to practice in Washington and Pennsylvania. A little bit about my background. I grew up on a farm south of town here. In fact, my parents just moved off the farm. My brother runs it now. Graduated from high school in Warden. And anyway, just decided that farming, getting dirty, greasy wasn't for me. And the irony that now I'm an attorney is not lost on me.
That's awesome. So, and go Zags, by the way. It's really too bad that they didn't get to play in the tournament this year. That's really a tragedy. So tell us a little bit about the way I got connected up with you was I did a Facebook post with my son's hospital billing and on my Sickened page. And if you guys don't know, I wrote a book called Sickened: How the Government Ruined Healthcare and How to Fix It. And it's basically, it has the history of how the government actually caused a lot of the pricing issues that we have in healthcare and the service issues. And there's a 6-step solution in that book. So go to Amazon, download that book, Kindle version. We're working on an audio version and a paperback version, hopefully to be out later this year. Anyway, on that post, you commented on it about hospital pricing and about this lawsuit that you have going on. So can you discuss that a little bit?
Yeah, sure. So what we've got going is a lawsuit. It's actually in the Western District of Washington. So it's United States District Court, federal court. Most of our court system that folks are familiar with in terms of, that they may deal with is state district court handles, misdemeanors, gross misdemeanors, civil cases that have $75,000 or less. Some people, family law issues, may end up in superior court. Most of the litigation that's done in our area is probably as between superior and district court in terms of state superior and district court. The federal district court is, it's actually a court of original jurisdiction, one of the first courts that was established by the founders. And so there are only so many of those that are spread around throughout the country and throughout the state. So our case is in the Western District of Washington. Washington's split into 2 districts: the Eastern District, which is primarily based out of Spokane, and then the Western District, which is primarily based out of Seattle. And so this case arose actually out of an issue, a billing issue that happened in Kennewick. The reason that it's over on the west side is because that's where the company's registered agent was. Anyway, so what the lawsuit is about at its very core is it's a consumer protection case. And the reason that it is important is because in cases like this, people go to, for example, an emergency room. And they are, if you think about the way that people interact with healthcare, it's different from going and shopping for your primary care provider, right? You may ask friends, you may look around, you may say, look at reviews online, you may call, you may even interview some different primary care providers just to engage with a certain degree of, discern your comfort level. When people go to the emergency room, it's a different story altogether. And they're vulnerable, they're captive. Nobody's shopping ER. You're not going to go to the ER and say, well, this is not a good deal for me, I'm going to go to a different ER. When you go to the ER, you need emergency care. It's by definition, right? It's the nature of the room. So the issue becomes that people go to the ER and they receive care, and then they receive a bill after the fact. It's not a menu from which you select your services. You get a bill after the fact. And the case is about this at its very core. And then this issue of surprise billing, balance billing. And when we talk about surprise billing, balance billing, anybody who's been to the ER knows, and I know we're going to talk about your individual situation here in a bit, but anybody who's been to the ER knows that, or any healthcare knows, you can anticipate a bill. And that's not necessarily a surprise. There may be a negotiated rate. You may have your insurance. It's got a copay. You may have a deductible. But the issue becomes after these things you believe these things have been covered, in the ER context, you get a bill from some other entity. All right. It's not the hospital that you went to. Very often it's a physician's group. And in this case, it's an emergency physicians group that has a very local sounding name, but is actually based out of Florida. When you see this, you say, well, who are these people? Who am I paying? What is this service for? It's in fact, it's a national entity that services 650 places around the country and sees millions of, they tout on their website, millions of patients every year. So, what the lawsuit is about is this issue of ER, consumer protection. You get this bill, and this bill, as I'll point out here in a little bit, is several times what the standard charges are. And so our effort on behalf of a particular person out of Kennewick, but then broader or more broadly, we're trying to get a class action going on behalf of people nationwide. And so far, so good. We are awaiting word on a motion from the magistrate judge who heard some argument last week. We expect to get that here in the next 2 to 3 weeks.
Oh, good. Well, you'll have to keep us up to date on that. I'm super excited about that. So isn't there some law that was passed earlier in this year about the surprise billing, balance billing, that gives this case more credibility, or is that true?
So there is definitely a law. It doesn't necessarily specifically apply to our case.
Oh, okay.
And the reason that is because our case, the care that was rendered was given before this law was enacted. This law passed, it's called the balance billing law. And the idea is that consumers shouldn't be surprised with a balance after they've received this care, they get this bill. They shouldn't be getting sort of arbitrary, capricious charges that they weren't expecting. So
yeah,
that
right.
law,
Go ahead.
That law was passed. The bill was passed in 2019, went into effect January 1, 2020. But in terms of our case is developed what you'd consider more common law. If it violates the statute, that would be obviously a statutory case. You'd have a statutory basis for bringing your claim. Our case is different. Our case is based on common law unconscionability of an adhesion contract, so a procedural unconscionability, which is the idea is that you have no bargaining power, and then substantive unconscionability, the idea being that the charges are exorbitant and so extraordinary compared to what the standard charges ought to be.
Well, it seems that's kind of commonplace with hospital billing. And speaking of the surprise billing, I can attest to personally, I wasn't surprised by getting the bill, and I wasn't really surprised at the price, because I knew it'd probably be anywhere from, which is just crazy to think about, I knew it'd be anywhere from $10,000 to $40,000. My son was in the hospital for less than 12 hours from the time he was admitted to the ER, and a little more than 12 hours from the time he was admitted to the ER to the time he was released to go home post-surgery. And I'm going through the details of the bill now, and the charges are exorbitant, and they just seem unreasonable. And here I am. I'm somebody that's in the healthcare profession. I've worked at the hospital. I've been a commissioner at the hospital, so I know how these things work. I can't imagine, your typical consumer that are accessing these services that can figure the system out. And I think that's probably why they do it. They keep it complicated because it makes it harder for consumers to compare pricing. They don't want people to. And I think there are individuals inside this. In fact, I know there are individuals that are inside the system. They know it's a racket. They know it's a scam, but they're just doing what they're told. So tell me, in your lawsuit, are you going to get depositions from people inside hospitals that know more details about these billings? Because if that happens, you just think it's going to open up a can of worms for these hospitals. You're going to think they don't want that to happen.
So on some level, that's what we're optimistic for. The fear of discovery and the discovery process is, on some level, what may bring these folks to the table and cause them to change their their billing practices. I should point out that in addition to the relief that we're seeking on behalf of the class, from a financial perspective, we are also seeking injunctive relief, which requires these outfits to modify their practice. You mentioned the difficulty of addressing pricing. I know we'll talk about this a little bit later, but it was just last year that President Trump actually signed an executive order requiring hospitals to inform patients about actual prices. And that executive order led to CMS, the Center for Medicaid Services, issuing a number of rules that actually resulted in hospitals filing a lawsuit in order to attempt to prevent pricing from being published.
So the hospitals are suing because they don't want to make their prices public. Is that what you're telling me?
That's correct. In that particular lawsuit, it's also a federal lawsuit. It's been filed in the United States District Court for District of Columbia, Washington, D.C. And that was specifically filed by the American Hospital Association and a number of other entities. They filed a lawsuit against the Director of Health and Human Services, Secretary of Health and Human Services, Alex Azar, in an effort to prevent this law from going into effect. It actually isn't scheduled to go into effect till 2021, but it's interesting that they filed this lawsuit. And when you think about, so you think about our lawsuit and that lawsuit, in the challenge that folks who are trying to get a good understanding of what they're spending on healthcare is, you've got on the front end hospitals fighting to prevent disclosure of advanced pricing, and on the back end you end up with consumers receiving bills that are far and away above what these standard charges are that nobody's telling people. And so when you think about, you tie it in, you can tie these lawsuits together, I think, pretty consistently. There's definitely a problem for consumers. And again, it's this hidden world. There's lists, and we'll talk about some of those that are available online to consumers. But there's these things that consumers just don't have ordinary access to, that our government's trying to make more available to patients.
Well, yeah, it is. There are big lists, and they can be kind of complicated. We'll go into one that you make it a little bit easier. But one of the goals is that I wrote a book and also have this radio show / podcast is so we can educate and empower consumers that they are in charge of their own healthcare, and that includes that fiduciary responsibility. So they should be able to shop prices and make sure that they get the best service at the best price, and not just let a government agency or their insurance company take care of that, because that's part of the problem when we wash our hands of our own responsibility, and most people don't even see these hospital bills. So please, people, ask for detailed hospital bills. Look what these charges are. It doesn't matter what your insurance company pays or doesn't pay. Make sure that you're getting the services at the appropriate price. And the insurance companies negotiate prices all the time. They don't pay the regular real price, the price that they're billed. And we're going to get into that a little bit later. Bryce has a great spreadsheet that can show us how to shop a hospital price. So what are your so what is on your lawsuit? You're asking for injunctive relief, and then they need to change their practices. So what does that look like?
Sure. So the idea at its core would be that the actual charges that are going to consumers would be reduced. When we're talking about, if the average or standard charge is, $150 or $200, then a person shouldn't be receiving a bill for $800 or $900 or $1,000. You say that it's one of those things that you could say to an elementary school kid,
right?
And it's like, is it fair that something that, costs $100 is being charged out at $1,000? And, the answer to that's, obviously no.
Bryce, it's amazing we are even talking about it. It's the only industry where stuff like that happens, and it's because there's a third party involved, and that's part of the problem. And you can read about that more in my book, Sickened: How the Government Ruined Healthcare. But let's go a little bit into that lawsuit with the American Hospital Association, and that's a federal lawsuit in Washington, D.C. or something. Can you go put that up and show some of the details of that lawsuit?
Sure. So give me just one sec, and
Yep.
All right. So you should be able to see. In fact, I'm going to blow this up just a little bit. Can you see my
I sure can.
Adobe?
Yeah, we sure can.
Yeah. All right, good. So I'm going to show folks two things that are important or germane to this lawsuit. The first thing is this, and this is the actual lawsuit that was filed in the United States District Court, District of Columbia. You can see here, this is the complaint. At the time that it was filed, it didn't have its case number assigned to it. But on some level, this, just so you know too, this case is actually already resolved. Okay, so and I'll get into that here in just a little bit. It's resolved to an extent. But you can see here who the people were who filed the lawsuit: American Hospital Association, Association of American Medical Colleges, Federation of American Hospitals, National Association of Children's Hospitals, Memorial Community Hospital and Health System. I don't necessarily need to read all these, but and they brought this case against obviously the Secretary of Health and Human Services. And so what this lawsuit describes is that this executive order that generated this series of rules from CMS requiring disclosure of these various prices was something that the hospitals have been and are fighting very hard to prevent disclosure. When I say this case is on some level resolved, the reason is because you can see here, and the reason I'm pointing this out, and I'll provide it so your listeners, your viewers can get access to this. Anybody who wants this information, this is within the public domain. I'll send it to whomever. But this is a memorandum opinion from Judge Nichols in district court. This is rendering summary judgment in favor of defendants, and defendants in this case being Secretary of Health and Human Services Alex Azar. So the significance of that is that as of today, this is on track to continue into law. It's January of 2000. Give me just one sec. I'll tell you exactly. I think it's so. Yeah, final rule is scheduled. Can you see that? Final rule is scheduled to go into effect January 1, 2021. I did have an opportunity to look into this a little bit more as far as what the plaintiff's plan is. Plaintiff's plan is clearly to appeal this ruling, and it may be something that we ultimately see at the Supreme Court, United States Supreme Court. But as things stand right now, you can see, and I just want to point some of this out, because these issues that we're talking about, Shawn, that you're talking about, is it's something that touches on certainly so many people. And I'll go through some numbers from our lawsuit here in just a sec. But you can see here, this is an observation by the district court judge. The impenetrability of hospital bills is legendary. Hopefully people can see that. It's an arcane art, mystifying. And hospital billing has been the target of regulations at the state and federal level for years.
Wow.
So, it's interesting. Here, I'll read you some citations from our lawsuit, just to give people an idea. People can imagine it, but I think sometimes the numbers are stark. You figure we got 330 million people in our country, give or take a few. So bear with me. 56 million Americans under age 65 have trouble paying medical bills. 35 million American adults between the ages of 19 and 64 are contacted by collection agencies for unpaid medical bills. 17 million American adults receive a lower credit rating on account of high medical bills. 15 million American adults use all their savings to pay for medical bills. 11 million will take on credit card debt to pay off hospital bills. 10 million are unable to pay for basic necessities like rent, food, heat due to their medical bills. 16 million children live in households that struggle with medical bills. And despite having insurance coverage at this point, 10 million insured Americans are faced with medical bills that they're unable to pay. This is also significant. 3 in 5 bankruptcies annually, so that's 643,000 bankruptcies, are due to medical bills.
Wow. That's astonishing.
The numbers are staggering. So, when you think about the amount of people that are impacted by, for example, the rulemaking efforts at CMS, or potentially impacted by the efforts of the hospitals by way of this lawsuit, and potentially impacted, hopefully positively, time will obviously tell, but impacted by our lawsuit in the Western District, there's a significant number of people who stand to benefit or be burdened, depending on the outcomes.
Yeah. So you had a few other things highlighted in this District of Columbia lawsuit. Can you go over those?
Sure. Some of these are just my own notes, but you can see here. So there's a document the hospitals keep. It's called the Charge Master.
Mm-hmm.
And you can see here that the observation from the district court is that charge master rates are highly inflated and often bear little resemblance to the actual payment tendered to a hospital by a patient or third-party provider.
Let me talk about that just a little bit, my personal experience. So, first of all, you can you can find it up on YouTube, and we can even share it on this episode later. It's called Adam Ruins Healthcare, and it's about hospital pricing, and he talks about the magic charge master. And I will tell you that hospitals hide behind that. They hid behind it when, with my son's case, they said, "Oh, well, yes, this is very transparent. We do post our prices. You can get a link to our charge master online." So I go online. Had a difficult time. The link was broke. I finally figured out with some help to how to get into the link. And the charge master, the magic charge master, was 688 pages. So here's what they don't tell you about that charge master. The charge master does nothing when you ask a hospital, well, I need a total knee replacement. What's it going to cost? You can't look into the charge master and see what a total knee replacement will cost, because there's details on, after you get the bill, there's so many details that are on that charge master, but it's pages long. And if you look at my Facebook page, you can see the detailed hospital bill where, my son got charged $19 for one pain medication tablet that, cost the hospital pennies. So that magic charge master, it might sound like a way that hospitals are transparent and posting their charge master, but it's still so confusing that nobody knows what is going to be charged from that charge master after a certain surgery or procedure. So really what hospitals should do when I talk about transparency and pricing is, hey, you have a colonoscopy, you have a total knee replacement, then you should list that price. And that should be all inclusive. Oh, you say, hospitals say, that's too complicated. There's a lot of things here we just don't know about. That's not true. They do those procedures all the time. They should know what they're going to cost. You know what? Surgery Center of Oklahoma, they post their prices online, and when they say what a total knee replacement is going to be, that's what it's going to be. There's no surprise charges. There's no surprise billing 6 months later. It is what it is. It's all inclusive. So hospitals can do that. It is happening. It can happen. So yeah, what's some more of these things you highlighted, Bryce?
Sure. So speaking specifically to that, you can see here, and the nice thing about an opinion like this coming from the district court for DC is that it's highly researched. There's many citations that folks can, if people want to go dig for this stuff, hopefully we can make it a little bit easier for them to find. But they can access, and then they can learn, they can educate themselves on some level. But if you look here, I highlighted this: hospitals may inflate the costs in the charge master more than fourfold, and that some services can have charge to cost ratios of almost 30, right? So 30 times more than the actual cost. You see here that citation goes to this footnote: the average charge master price for an appendectomy was over $18,000. Indigent uninsured paid $1,800. Medicare recipients paid $4,800. Insured person paid managed care $6,100, and then payments by a non-indigent uninsured, so a person who's got an ability to pay, the hospital's actually having pay even more than all those folks. So the variability in terms of pricing
Wow.
is pretty insane. And
Well,
keep in mind, so you pay this, and then you get socked with a bill, for the outstanding balance. I mean, that's devastating.
so this lawsuit is all public record. This is an opinion of the court. So yeah, highly researched. Here's my takeaway from this. This is not a legal opinion. This is my takeaway from this is that nobody should ever pay full price at a hospital. When they get that bill, they should negotiate it, and they should argue these points all the time. They should ask for discounts. They should say, all these questions, because it looks like nobody really pays the full price. I mean, I wouldn't say nobody, because there are certain people that do, unfortunately, but most people don't pay the full price. So it's unbelievable to me. I mean, it's like no other industry. Unreal.
I think, yeah, I think the significance of it is that this it's almost like a car, right? The sticker price is not exactly the sticker price,
Right,
and
right.
that's something that I think folks will benefit from. Let me show you, because I know I'm still showing my screen. This is actually a website that folks can go to, Office of the Insurance Commissioner, what consumers need to know about surprise or balance billing. And that's something that people can go to and find out what their rights, what their options are. I mean, obviously they can call an attorney, they can do their research, they can negotiate with the hospital themselves. But you can see here the new Balance Billing Protection Act. So this is the one that went into, this is a Washington state law. All right. So it's important to be clear that the CMS rule-making process, that's federal. And then the Balance Billing Protection Act is a state law. Okay. So the Balance Billing Protection Act applying only in Washington state, whereas the CMS rulemaking procedure would apply nationwide. But you can see here, new Balance Billing Protection Act prevents people from getting a surprise medical bill when they receive emergency care from any hospital, or if they have a scheduled procedure at an in-network facility and receive care from an out-of-network provider. If an insurer and provider cannot agree on a price for the covered services, they go to arbitration and cannot bill the consumer for the amount in dispute. Okay, so there's certainly some protections for people.
Yeah, so we're going to provide. So let's make sure I'm talking to my producer slash video editor now. Let's make sure that we put a link to this in our show notes, podcast notes, YouTube notes, so our listeners and viewers can get to it easy. Also, that lawsuit that you've got highlighted, everything highlighted, the one in DC. Is there a link to that, or how can we post that? What's the best way we can get that on these podcast notes YouTube site? Is there a link for that?
Sure. So this was pulled directly off the internet. there was an article, you can see it here, judge rules against hospitals in price transparency lawsuit. And within that, there's a link, but also in the direct PDF. So it's not buried.
Perfect.
But
Perfect.
there
All
you
right.
can see this is the actual memorandum opinion again, certainly within the public domain.
Yeah. Let's make sure, video editor, that which is my son Jordan, who did break his leg, but he's still working hard as ever. Make sure you put that in the show notes and the link in there, Jordan. Thank you. Okay, so that wonderful charge master with ER visits. We were talking pre-show. We were talking about how this surprise billing happens a lot with ERs, because probably because, maybe not, but hospitals take advantage of an ER situation because they can. It's not price shoppable. So tell us about, there's a tool that you have to make sure charges are reasonable, an Excel spreadsheet. Can you show us a little bit about that?
Sure. So I'll bring up the spreadsheet right now, and I'll show you. Interesting thing about this primarily is this is not something that we compiled. This is something, again, like so many of these tools, it's within the public domain. But when we say that, even though it's accessible, I mean, on some level, this is what I do for a living. You're within the healthcare industry,
Right.
But bringing all of these resources to bear in one concise location, it's just that part of the puzzle is not available. So this spreadsheet actually comes from the website that we reviewed earlier, from the Office of the Insurance Commissioner. Okay, and this is downloaded from there. You can see here it's let's see, Washington Office of Financial Management, but it came from the other website. But the significance of this is that you can get a sense for what the average charges are for different CPT codes. All right, and CPT codes are billing codes that the hospital uses to get paid. In our case, I want to be clear too, it's not specifically the hospital, it's an agency that's coordinated with the hospital, contracted with the hospital to provide care. The point is that it could come from a variety of sources. But as you're looking at this, you can see these CPT codes. Now, the ones that we have been investigating around the state are 99281 through 285. Okay, and I've got those highlighted. Hopefully you can see these clearly right here. And you can get a sense by looking at this in network. So you see here, so 99281 would be a relatively low severity emergency department visit. 99285 is the highest. Okay, and then you can see here in network, out of network, you can see the number of claims annually, the median charges, and then the median allowed charges. And so just to put this, a little bit of perspective, imagine you get a $900 bill, but the allowed charge is only $326, right? And so,
Wow.
So this is, it shows that the charge is very often quite a bit higher than the allowed amount that a person, or rather the hospital, is getting paid.
Well, so my son's charge for the ER was $1,806, I believe. There's also another charge on there that I'm questioning. I think it's a facility fee. I'm not sure, but it's just another $500 charge for ER services. I don't know why there's two different charges. Oh, I know why, because they can increase their charges and maximize their billing. I know that's why, but that doesn't necessarily mean that insurance companies pay that or anybody pays that. That's why it's important to look at your bill and get a detailed bill. But so I think there's one on there that's about $1,400 or something, and 985 and 285.
Yeah, I'll show you that here in just a sec. So what you're likely referencing is a combination of CPT codes would be, and that's just my suspicion. Obviously, I haven't seen it. But so this is statewide. This is the averages for statewide. But if you can go regionally too. And you can see here Now I don't have 99281, 8283, 84 highlighted. This is 85, and it's broken down by region. You can see here southeast, south central, west, northwest, northeast, south, etc. And then you have the difference between the out of network and in network charges. And if you take just, this is probably one of the more egregious examples. You look at northeast, okay, that's not where we're at, but out of network and in network, $1,471, with the allowed charge being $284 and $285.
A sevenfold difference. I mean, I don't know what to call. I don't know what the legal term would be. Robbery, extortion. But for the people that actually the hospitals billed that $1,471 and the people paid it, that is almost extortion in my opinion. I mean, it's unbelievable to me, and it fires me up, and this is why I'm so passionate about this subject. I want to make sure that consumers are educated and empowered, that they have some control over this. So one of the most important things, consumers, is when you get that hospital bill, get a detailed bill, and make sure they give you the CPT codes. As you can imagine now, that we're exposing some of this stuff and we're making it easier to find out pricing of CPT codes. Do you think hospitals want to give that to you to start with? No. That's why my sons wasn't on there yet. And that's why it's been almost 6 weeks and I've been asking for those and I don't have them yet. I am going to get them, and I am going to go public with this information and show what the average charge is, what my son's charge was, and what the average allowable is. So my opinion is people should not pay more than that average allowable. It is not fair that some government entity or insurance company negotiated a price and they pay less than your quote-unquote uninsured consumer. So I thank you for showing us this, Bryce. This is a great tool. Go ahead.
What I was going to say is that's on so many levels. That's the hallmark. You term it extortion. It's a hallmark of our lawsuit, the lawsuit that we've got filed over in the Western District. What we're referring to, the legal term on some level, extortion certainly is a legal term. It's a crime. But what we're talking about in terms of the implied contract, the contract that's rendered as a result of the service, they say, well, we provide you service, so you owe us money. What we're referring to is what we call procedural and substantive unconscionability. Okay, it's unconscionable what they're doing, and that's the core of the lawsuit. So from a procedural standpoint, what we're talking about is the way that this contract is entered into. You got captive, vulnerable people who are going to the emergency department. They have no bargaining power, right? So this is procedural. The process of entering into this implied contract is unconscionable. And then when we're looking at these charges, the disparity in the charges, as you mentioned, sevenfold, and some of these, they range, from about threefold to sevenfold. That's substantive unconscionability. It's you say this is what the price ought to be, and the price is many times over and above that. Well, that's unconscionable. That's unreasonable. And so that's exactly what we're working to correct.
Yeah, it definitely. You said earlier in the podcast about, I don't remember if you said elementary school person or a kindergartner can just see some of these things and just think that it seems to be unreasonable. I mean, it truly does. It's obvious. I appreciate you being on today and exposing some of this stuff and educating us. That's what this radio show and podcast is all about. So, do you have anything else that you would like to go over today to educate our viewers and listeners?
Specifically, no. What I would say is I will make all this data and these documents available to you and your listeners. If folks want to find out a little bit more about us and reach out to me to see what some of their options are, they're certainly welcome to visit our website. It's pretty simple. It's just www.mcpartlandlaw.com. We're a Google search away if nothing else.
Awesome. So what is I know it's really hard to predict these things. What's your timeline with your lawsuit?
Well, we'll have a good sense here in another 2-3 weeks what the judge is going to allow, if anything. One thing to keep in mind is that even if this particular lawsuit doesn't work out, it applies at the moment only to one person's claim. It doesn't mean that this stuff isn't happening. So if people do get these surprise bills, these balance bills, specifically referencing these CPT codes, again, 99281 through 99285, those are something that they can send to us, and we can evaluate the viability of a claim for those at no charge to whoever's asking.
Awesome. So I think that's a great comment too, is that just because you might lose this first round doesn't mean you're going to lose the war. Obviously, when we look at the documents that you shared today with that lawsuit in Washington, D.C., this is not a new issue. This is a big issue all over the country. And it is up to us as consumers. It is up to people like you and I, Bryce, to educate people on these things so they can fight them. And, you mentioned it earlier. I got to tell you, I thank you for going through that document. You've sent me that Excel spreadsheet before, and I didn't. I don't work with it every day like you do. So even though I'm in healthcare, I don't navigate it like you do and know how to navigate some of these legal things. So that's why it's important for us to let consumers know about these tools. And you mentioned it too. It's like you do this every day. So to you, this is just common. This is just common practice. It's kind of like what my wife and I. One of the reasons we decided to have a radio show is because we took all these things for granted. It's like, well, we deal with this every day, so it was no big deal to us. But when we talk to consumers, they just didn't know these things. So I'm so glad that we have this forum to educate and empower consumers, and I appreciate you having being on as a guest today, Bryce. And that wraps up our midweek podcast with Health Solutions with Shawn and Janet Needham, where Team Needham discusses everything healthcare. Do not miss out Monday. I don't like to be picky or discriminatory about what guests are going to be the best, but I will tell you this one's going to be a heartbreaker. Actually, it's a loving story because it's how somebody's life was turned around by changing their diet. We talk all the time about diet and how it changes people's obviously diseases like diabetes and hypertension and high cholesterol and things like that, and their weight. We talk that all the time. This girl, her life was changed with the ketogenic diet with seizures. She was having 25 grand mal seizures a day. She changed her diet, and within 48 hours, she was seizure free. All the neurologists, all the meds couldn't help her. The ketogenic diet did. That's a very, very important thing. You guys do not want to miss that Monday, streaming live on my personal Facebook page and the Moses Lake Professional Pharmacies YouTube. And we will be live in the AM 1470 KBSN studios out of Moses Lake, streaming on the airwaves too. So you do not want to miss it. 1 to 2 p.m. Check us out, and we will talk to you all later. Thank you.